Yes, Mr. Karras.
My Lord, my submissions will broadly follow the structure of the 6 propositions which are set out in our case. After that, I will endeavour to explain why the arguments that March should either be distinguished or departed from in our submission don't stand scrutiny. And if there's time, Mr. Marici will deal with any environmental questions left over, and in particular points of correction about the scope of the Environmental Protection Act, which we submit is peripheral to this case, but might have wider implications. If we don't have time, he has prepared a short note which has been sent to the court.
Yes, that's the one about statutory nuisance.
Statutory
nuisance. Yes,
nuisance.
we received that this morning.
I'm obliged. Before making my submissions by reference to the propositions, I propose quickly to note 7 points which are either common ground or at least we submit uncontroverted by the evidence. The first point is that the infrastructure with which we are concerned was constructed pre-privatisation. The second point, which you've heard from Mr. Delamere yesterday, is that because of our statutory duties under Section 106 and Section 116 of the Act, we can't stop people from connecting or force them to disconnect, save in certain circumstances. This means that over time, sewers which were considered adequate when built are in practice likely, in certain instances at any rate, to become inadequate. The third point is that the judge at first instance and in the Court of Appeal, the judges at first instance and in the Court of Appeal held that the discharges with which we're concerned in this case would, if proven to be, if proven as a matter of fact, would amount to breaches of United Utilities duty under Section 94 of the 1991 Act. I won't take the court to the passages. I'll give the court the references. In Mr. Justice Fancourt's judgment, it's at paragraph 79, I think between E and F, on page 269 of the bundle, and in the Court of Appeal, Lord Justice Nugee dealt with this at paragraphs 59 to 61, and it appears at this level, at any rate, to be common ground because we understand that finding has not been appealed against. The fourth point is that on the unchallenged evidence, the only way of remedying the situation is the provision of new infrastructure. And the fifth point on the evidence is that building new infrastructure is both costly and cannot be achieved overnight. And we summarise the evidence in our case at paragraph 10 on page 126 of the bundle and paragraph 27 at page 131. The sixth point, which is something you haven't heard anything about in any detail yet, is that there is now specific statutory requirements for the Secretary of State to adopt a plan for the reduction in polluting discharges from outfalls, and that's found in the Environment Act 2021, which inserts provisions into the Water Industry Act 1991. This, we say, is relevant for 2 reasons. First, it is relevant to the question of whether or not there should be a departure from Marchich, this being a matter of recent parliamentary legislation, the subject matter being overlapping considerably with the subject matter of this case. And secondly, of course, one needs to construe the Act as it currently stands, or the court can't shy away from that, even though that Act wasn't in force at the date the proceedings were commenced.
So the 2021 Act has inserted provisions into the Water Act
Yes.
1991,
And they are-
requiring a plan to be drawn up. Has there been any use of that power?
Yes,
Yes.
I'll take the court to it because it illustrates in some detail the factual situation against which sewerage undertakers are in practice able to deal with the problem of inadequate sewerage infrastructure leading to polluting discharges. The seventh point is that whether or not the remedy is achieved under the new process or apart from it, the cost will ultimately be borne by consumers, either immediately through charges or ultimately because sewerage undertakers are in practice going to receive a return on any capital investment they make. And I'll come back to that when we look at section 2 of the Act. But those are background matters. Now, turning to the propositions, the first proposition is that a claim in respect of polluting discharges, in this case, would, if proven, amount to a breach of Section 94. This is, on the face of things, unchallenged, but I propose briefly to take the court to the substance of the claim which we face, because the court, of course, has to decide this particular case. The claim which we faced from the Manchester Ship Canal Company had two features to which I draw particular attention. The first is that the threatened claim related solely to polluting discharges. I'll make that good in a moment. There are suggestions in the written case of the Ship Canal Company that the issue goes to matters wider than that. We say that is wrong. The case which we faced, and in respect of which we sought declaratory relief, was limited to polluting discharges. The second feature, and this is common ground, is that we are not concerned in this case with claims which result from pollution arising from the negligent operation of our existing systems or deliberate wrongdoing in operating them. Indeed, none, as we'll see in a moment, was alleged against us. That these are the features of the claim can be seen from an application which was made to Mr. Justice Newey to amend the previous 2010 proceedings. Mr. Justice Newey refused the application to amend the proceedings, but that did not preclude a new action being commenced, and we have had that action hanging over us, hence the need for declaratory relief. If I can take the court very briefly to the way that it was put, the relevant passages are, for those working on paper documentation, in Appendix Volume 1, Tab 11, and the application starts on page 418, but the relevant paragraphs start at page 424, paragraph 16C, it refers to authorization by statutes. Such discharge from pre-1991 articles are not expressly authorized by WAIA 1991. Then one sees over the page, at page 425, 16C.4. By reason of section 1175 and section 1863, the statutory right impliedly conferred by the 1991 Act to discharge and other materials in the canal does not authorise the defendant. Then one sees the limitations. Then over the page at 426, one sees by reference to a schedule a claim that the limits of section 1175 to 1863 would be contravened, and they set out in the schedule a list of outfalls, and the schedule appears at page 441. A list of outfalls which are said in the column category B, yes, they say, where there's been a contravention. So there are a number of outfalls which they say contravene the provisos. Of course, this is in issue. And then we see the relief which they claim in respect of those outfalls back on page 431 of the bundle. At paragraph 43 on page 431, they say the claimant is entitled to an injunction, but they don't claim an injunction. What they claim is damages. And at paragraph 40, one sees the loss and suffering which they say they have suffered. And they say they're entitled to a measure of damages which reflect a reasonable price for the acquisition of a right to make such discharges or the loss of an opportunity to negotiate such a price. They say, though we don't accept, that they are entitled to negotiating damages. So in essence, what they're asking for is compensation for loss of a license fee to, for permission to continue breaching our statutory duties. That is in essence of the claim, which we face. We submit that there are three important aspects underpinning this claim. The first is that it is common ground that we are entitled to discharge from the outfalls in the event that we don't contravene these provisos. That follows from the 2014 litigation. The second point is that in order to contravene the provisos, the water of the canal must be prejudicially affected or injuriously affected. And the third thing is the point that I made earlier, which hasn't been challenged, is that this, in essence, in substance, requires findings of fact which amounts to a breach of the Section 94 duty. We'll come back to that. In essence, we say to get the claim off the ground, whether you frame it in trespass or nuisance, there has to be a breach of the Section 94 duty. That's the claim we face from the Manchester Ship Canal Company. The Environmental Law Foundation puts their position slightly more, well, we say actually a lot more attractively at first blush. They suggest, I didn't take the court to it, paragraph 4 on page 175 of the bundle, that the existence of a common law claim would provide a potential incentive for us to improve matters. Now that, on the face of it, sounds both attractive and indeed innocuous. The practical effect of this, in my submission, can be seen from a description of the court at first instance in a parallel piece of litigation to this litigation. It's a decision of Mrs. Justice Thornton, and it appears at page 2920 of the bundle.
Just before you go on, I'm just pondering on the point that you have just made about injurious affecting the water. That applies even vis-a-vis a trespass claim, does it?
Well, we say injurious affection by its nature is predicated on there being a claim that would amount to a nuisance. And in due course, I'll take the court to the Wild Tree case, which describes succinctly the historical origins of the notion injurious affection. But for my purposes, whether or not the claim is a trespass or a nuisance claim, underpinning that claim, to get the claim off the ground on what we say is an uncontested basis in this court, there has to be a breach of the Section 94 duty.
Can I also just clarify one thing? My understanding is that the factual position has been reserved as to whether there is or isn't a breach of Section 94.
Yes.
But your case is there may be a breach of Section 94.
I think it would be unrealistic for a sewerage undertaker in the current environment dealing with both Victorian outdated infrastructure and climate change and development to say that there are no breaches. And when we look at the government's plan for reducing polluting outfalls, one will see the scale of the problem. So there are breaches somewhere. Whether or not in relation to the canal, we do reserve our position as to whether or not there are breaches, because as one's seen from the evidence of Mr. Hazlitt, there have been enormous improvements in the water quality of the canal.
I was just wondering whether your clients have complied with their obligation if a company is aware of any circumstances that may materially affect its ability to carry out its regulated activities. It's a license requirement that informs Ofwat as soon as possible. I was wondering whether it's informed Ofwat of its potential breach of Section 94.
I think there's been we don't have evidence of that, but there is a constant dialogue between United Utilities and the Environment Agency, both the Environment Agency and Ofwat, and I simply do not have details of the extent to which there may or may not be breaches in this case.
Ofwat appear to be unaware because the footnote 7 on page 14 of the Appellant's skeleton argument sets out that Ofwat have been assured that all companies have allowed funding to comply with their legal obligations.
So that will have been part of the AMP process. Perhaps it's a point. It's obviously a relevant point of factual background. It's something I can seek clarification of over the short adjournment, because those behind me will know chapter and verse of the extent to which there may or may not have been a dialogue with Ofwat. I hope that'll satisfy your lordship for the moment.
I was just wondering about the regulatory capacity to enforce compliance with the obligation.
Well, the obligation is an enforceable obligation, and in practice, as I've indicated to your lordship, there is a constant dialogue with both regulators. If I can come to the Environmental Law Foundation's position, and their suggestion that there's a potential incentive. There's a case which starts at page 2920 of volume 8 of the authorities. I won't take the court to more than a couple of paragraphs of the judgment. That case, the background to that case was that United Utilities sought new rights to discharge into the canal from wastewater treatment works at Eccles. It did so by compulsory purchase. The order was objected to, and there was a public inquiry. originally, the Ship Canal Company opposed the making of the order in its entirety, but after some months of the inquiry, the Ship Canal Company conceded rights should be acquired, but they argued it should be subject to certain limits. One of those limits was that they sought that the rights which we wished to acquire would be subject to provisos which mirrored the provisos under Section 1175 and Section 1863. Now, under the statutory regime, it's common ground that those provisos are not automatically imported into rights acquired by compulsory purchase. Provisions for compulsory purchase are in Section 155 of the Act, to which the statutory provisos do not apply. The Secretary of State rejected that argument and confirmed the compulsory purchase order. The Manchester Ship Canal Company brought a statutory appeal and made a number of arguments, but one of those arguments concerns the effect of the provisos which they sought, and they said that the Secretary of State was wrong in the way that he treated them. And the judgment deals with those submissions at paragraphs 60 to 61. And it was the case of the Ship Canal Company at this stage that the breaches of the provisos would be enforceable in court. Paragraph 60 at 2943. One sees the Ship Canal Company seeks to criticise the inspector for construing the protection as equivalent to regulation by the EA, and this criticism seeks to downplay the precise and detailed system of control provided by the environmental regulation of UU's activities. Moreover, in closing submissions to the inspector, MSCC highlighted the position without a CPO in place where the owners of a receiving course could, it was said, regulate carefully the parameters of the outfall. One, like the court can read on what Mrs. Justice Thornton said.
So that quotation is from their written...
That's a quotation from their written submissions. And in essence, Mrs. Justice Thornton effectively summarised the position. If there is to be this parallel private incentive or private enforcement, one opens the possibility of what we would submit, and I would submit not hyperbolically, a possibly chaotic interaction between private regime and the statutory mechanism for securing improvements. And we refer to this simply as a useful summary of what could, in practice, result if there are rights through the court to enforce the provision of infrastructure which otherwise would fall within the remit of the regulator. Before I come on to the next proposition, while dealing with the Environmental Law Foundation's case, there's one point to pick up about a matter underpinning the way the ELF advanced their position. While taking up my Lord Reid's point yesterday that the court isn't a court of economic policy as such, underpinning the intervener's case, there is a suggestion that the problems which are faced are in part a fault of the privatisation regime. There are two points to make. The first may sound like an economic point, but it is a practical point. If the utility companies had remained in public ownership, or indeed were renationalised, the cost of upgrading the sewer system to remove the problem would fall on somebody, and it would fall on customers and or taxpayers. Somebody has to pay. But there's a further...
But the revenue wouldn't be diverted into paying dividends to shareholders.
It wouldn't, but this is partly the second. This is the second point, which I'm going to come to. There is a misconception in my submission underpinning the intervener's case. They suggest that there is an incentive for utility companies not to solve the problem by incurring expenditure. As we'll see when we look at the statutory scheme, in practice, there is an incentive for utility companies to persuade Ofwat to allow them to undertake as much capital expenditure as possible, because they, in practice, receive a return on that capital expenditure. And very often, in practice, it is Ofwat that requires utility companies not to carry out the improvements which the Environment Agency, or seek to challenge the improvements which the Environment Agency requires. And we see an example of that in the supplemental bundle, in an inspectorate decision provided by my learned friend. It appears in the supplemental bundle at tab 12, page 377. It's the second volume of the supplemental bundle for those using paper copies. It was a decision in which, it's page 377 the decision starts. We needn't go to the detail of it. It was a case in which United Utilities challenged the condition requirements of a permit. And one sees at page 380, at paragraph 16, indeed at the last sentence, the financial regime is flexible enough to allow you additional revenue if there is a change of circumstance. And this is the important point about the practice. But Ofwat expect you to test and challenge fully the basis of any new requirement placed on them. This may involve an appeal. And one has seen from the judgment of Lord Justice Newgie, at paragraph 24 of his judgment, I won't take you to it, at page 207 of the bundle, he refers to the challenge process. The dividends, of course, are the return we make on our investment.
And that is the price you pay for using private money rather than public money.
Yes.
For rebuilding the sewers.
Exactly, and if one were using public money, of course, it would either have to come from the customers, as we've said, or come from Treasury expenditure, which would involve either borrowing or higher taxation. That's the economic reality. Somebody has to pay. If it remains in public, if it's in public ownership, somebody has to pay. If it's in private ownership, somebody has to pay, and we'll get a return. And that's the reality. But the idea that we have an incentive not to carry out the works actually does not coincide with the way the regime works, because we like capital expenditure because that's what we get our return, or we are entitled to a return on.
Does that return come if the financing goes in by way of equity rather than loans?
I think however it works under the statutory regime, there isn't a distinction. So, as I understand it, Ofwat will look at the capital expenditure we undertake, make an assessment on how it's going to be funded, and allow a return whether on equity or loans.
Because you pay interest on loans.
Of course, and
the loans might come from third-party lenders.
Exactly.
But you would still get a return.
And one's entitled to a return one way or the other. It has to be paid for. The idea is, of course, that if it goes into private ownership, one can't expect the utility companies to operate at a loss. Well, the level of return, of course, is a matter for the decision of Ofwat. And of course, if the decision is taken that their returns and their dividends are too high, that is a decision for...
What I was trying to work out was why you should get increased dividends by reference to capital expenditure, which is funded by loans for which you pay interest.
Well, not through loans, but of course,
before you get the return, it assumes that the funding goes in by way of equity or something similar.
Quite so. If it's by way of equity, then there's a return. If it's by way of loan, of course, then the interest has to be taken into account in the charging regime. Otherwise, we are out of pocket. So your lordship is right to pick me up on that.
No, thank you very much.
So then come to the second proposition very quickly. The second proposition is that the Ship Canal Company's complaint can only be remedied through the provision of new infrastructure. That is common ground and appears in the Statement of Facts and Issues, page 62, paragraph 7, and the evidence is summarised in paragraph 25 of our case at page 131, and also the evidence of Mr. Hazlitt, which we've summarised the relevant parts of in paragraph 10 at page 126. And I won't take up any more of the court's time on that because it is common ground. The third proposition is one that I'm going to take some time on. It's that the Water Industry Act provides an elaborate scheme for deciding when infrastructure should be constructed to remedy breaches caused by insufficient infrastructure.
Before one moves from the second proposition, insofar as I understood the appellant's argument, it was that it wasn't a matter of enforcing the provision of infrastructure, it was compensating people who were subjected to nuisance. And so it was a matter of indifference to them as to whether or not you did or didn't provide.
It is a matter of indifference to them, but the nature of the complaints is that there are, we say in essence, is that the canal is being polluted. The only way of remedying perhaps the way I should have put it is the only way of remedying the cause of the complaints is the provision of new infrastructure. And when we look at the regime, we'll see how, in fact, damage plays a role actually within the Section 18 regime. But
they say, well, that doesn't mean that people who have been subjected to the tort of nuisance shouldn't obtain compensation for sewage being...
the point I'm making here is that for us, in order to avoid the complaint, in order to prevent the cause of action arising in the first place, assuming there is one, we would need to provide new infrastructure. So by remedy, perhaps the word is remedy. I've used the wrong word in saying remedy. The way of preventing the harm arising or continuing is the construction of new infrastructure. That I'd submit, is a better way of putting it.
That's a common case.
Exactly. That's why I'm not spending time on it. Yeah. It is common ground.
Yeah. But the appellant passed from you and saying, well, that doesn't prevent us from getting damages for the nuisance you create.
Exactly, and that's why we go on to look at the statutory regime in the third, fourth and fifth propositions, which I'm now going to come. Okay. So your Lordship is quite right to pick me up on the terminology I've used loosely.
Could I just ask, arising out of that, is it relevant to your case that the infrastructure we're talking about is infrastructure which United Utilities inherited from the previous undertakers rather than being infrastructure which itself created? Is that relevant to the point you're making?
Well, the infrastructure with which we're concerned in this case is all infrastructure which we have inherited. In principle, I respectfully submit that it should, as far as we're concerned, it should not. However, that isn't an argument for today. There extant in the 2010 proceedings, there are a number of outfalls which post-date privatisation, and the issue remains live in relation to those outfalls, whether this point could be taken in relation to post-1991 outfalls. So this case is concerned solely with the pre-1991.
But that has no particular legal significance so far as the issues before us are concerned. Is that right?
I would respectfully submit not. In my submission, there shouldn't be a ground distinction. However, of course, under the new regime, new infrastructure will be permitted through the process of discussion with the Environment Agency and Ofwat, and the problem is one which is unlikely or less likely to occur in relation to new infrastructure, because as we'll come on to see when we look at the amendments brought about by the Environment Act, the whole purpose is to reduce outfalls which have this effect. So it is a problem which is in practice less likely to occur in relation to post-privatisation infrastructure, because new infrastructure has been put in place under the new regime, where the Environment Agency will have an input. We say in principle it shouldn't make a difference, but in practice the problem is less likely to occur. Can't say it won't occur, because we have climate change and development,
All right,
but it
thank you.
is less likely to occur.
Thank you.
So if I can come to the statutory scheme, in our case we've referred to the statutory, or rather the factual background to privatisation at paragraphs 12 and 13 of our case on page 127, and I don't propose to take the court to that. The short point is that the state of our sewers in the late 1980s was pretty shocking. And the Act, as we go on to see, provided a regime which provided for regulation of those sewers, and we see through the parallel Water Resources Act regime and subsequent amendments, a permitting regime which restricted pollution and has in practice allowed for gradual improvement. If I can turn to the Act itself, starting at section 2, page 678. My learned friend took the court to this yesterday. I will pick out a number of points which perhaps he didn't emphasise. The first is that section 2 imposes general duties both on Ofwat and the Secretary of State in respect of the exercise of their powers and duties under the 1991 Act. This will be relevant when one comes to look at section 95, because the Secretary of State's powers to provide financial relief under that section are themselves subject to Section 2. Section 2A, my learned friend took the call to it, is the duty to further the consumer objective, and the consumer objective is defined in Section 2.2b. Section 2a(b) is a duty to secure that sewerage undertakers properly carry out their functions. But we see at 2.2ac the duty to secure that the undertakers can finance the proper carrying out of their functions, and we see in particular, we see that the duty includes a reference to securing reasonable returns on capital. 2.2ad needn't concern us, it refers to licensees, and they've been introduced to provide effectively a retail services. That doesn't concern us. 2.2ae, the resilience objective, is relevant, and if one goes on to the definition of the resilience objective on page 679 at 2 capital DA, there is, I submit, a relevant point here. The resilience objective is to secure the long-term resilience of water undertakers, supply systems, and sewerage undertakers, sewerage systems, as regards environmental pressures, population growth, and changes in consumer behaviour. And also to secure the undertakers take steps to, for the purpose of enabling them to meet in the long term the need for supply of water and the provision of sewerage services to consumers, including by promoting appropriate long-term planning and investment by relevant undertakers. So we see that the Secretary of State and Ofwat are required to take a long-term view of resilience. We say, and jumping ahead to the point that we'll make, which I hope I'll make good in due course, is that allowing private litigants who have sufficient resources to litigate their own priorities can cut across the long-term views which need to be undertaken when looking at long-term resilience.
Looking at it, another a striking feature of your case is essentially a breach of a rule of law, that your business model is based on breaching statutory duties. That's an inevitable part of the way you carry out your business, you tell us. And not only is the court meant to tolerate this, but those who suffer loss as a result of unauthorised behaviour, contrary, we're hypothesising, to a statutory duty, are meant to grin and bear it.
Well, we say that that's not quite right, because what Parliament has done has provided a statutory mechanism for providing remedies where there is a breach. If there were no provisions such as Section 18 and a blanket ban on all remedy, then I'd respectfully submit we would be in an area where the rule of law is breached. However, the important point is, when one's looking at the rule of law, as this court well knows, one needs to conduct a balancing exercise, and when we come to look at marchage and the principle of legality, which my learned friend referred to, marchage faced fairly and squarely the question of whether or not the exclusion of common law remedies struck the right balance. That was the human rights issue, in essence, in March. And I don't shirk from the difficulties which the point which your lordship has made raises, because in essence we have a system which, to be frank, since the 1875 Act, when these duties were first put on the sewerage authorities in the past, there have inevitably been breaches. It's the nature of sewers and the duty. I think since 1875, well, probably before, but certainly since 1875, when there was general legislation, the sewerage under authorities and the regional water authorities, and now the sewerage undertakers, have been playing catch up. And that is the practical problem which is faced. That, we say, actually is one of the reasons why there is a need for centralised, if one wants, regulatory, coordinated is a better word, a coordinated remedial regime, which is provided through Section 18, and that's the way Parliament has decided to solve this problem, rightly or wrongly. And that, we say, is what underpins Marchage when we come to it.
Just taking on Lord Reed's point, there's an inevitable breach of the Section 94 statutory duty. And your reply, as I understand it, is there is a statutory mechanism for such a situation where there is a breach.
That's the answer.
So there's no statutory mechanism for compensating the individuals concerned.
Well, there is, as we'll come to it, but it is limited. Under Section 18, there is a limited provision for compensation under Section 22, plus there is, and we'll come to it in due course, the provision under Section 95, which allows the Secretary of State, balancing all the matters, or having regard to, is the better way of putting it, all his duties under Section 2, to provide for financial remedy through that route. But I accept in practice there is no automatic right to full monetary compensation. There's nothing in the Act which requires that.
I just wondered whether it was more appropriate to consider it as being a statutory mechanism for correcting the cause of the breach rather than remedying the breach.
Well, if one looks at, we'll come and take a look at Section 18 in a moment. But one sees within that scheme, we say, a scheme which isn't concerned simply with causes, but also with consequences. Going back to Section 2, Section 2.4 on page 680 requires Ofwat and the Secretary of State to have regard to the principles of best regulatory practice, including the need for regulatory actions to be proportionate, consistent, and targeted only in cases where it's needed. We say this is significant because the requirement on the Secretary of State, indeed Ofwat, to target only cases where it's needed, envisages that the setting of priorities between the remedying of various breaches is a matter for the Secretary of State and Ofwat. And what is needed is plainly a matter of judgment, and as you've seen from our case, and I'll go on, I hope, to make good, is a matter which is vested in the Secretary of State and Ofwat rather than the court. And then in Section 2.6, one sees a list of the provisions which are subject to this duty, and one sees on page 681 that list includes sections 95 and 96, to which I'll come. It also includes section 18, which is in part 2. While we're there, it was suggested, I may have misunderstood what my learning friend suggested, it was suggested that Offport has no environmental function. That's not quite accurate. If one turns to page 684 of the bundle, one sees section 3, which puts Offport under environmental duties in relation to proposals, indeed, and one sees at subsection 2 the requirements imposed by this subsection in relation to any such, well, perhaps we need to look at one first. So, but the duty of each of the following, that is to say the section stating the authority and the companies, in formulating and considering any proposals relating to any functions of a relevant undertaker, requirements in relation to the proposals by subsections 2 and 3. So where one is considering remedy, which is one of the functions under section 18, one needs that the regulator is under duties to consider, in particular, exercising any power conferred with respect to the proposals on the person subject to the requirements as to further conservation and enhancement of natural beauty, conservation of flora, fauna and geological or physiographical features of special interest, and in the case of the exercise of powers by a company holding an appointment as to further water conservation. So it's not, there is an environmental environment has to be taken into account where proposals in relation to functions are being considered. I need to entertain the court with sections 6 to 17, which deal with the appointments of companies as undertakers. My learned friend took the court to section 11 on page 689, which permits conditions to be attached to appointments. He suggested that the charging regime is effectively dealt with through conditions in appointments. That is only a partial description of what goes on, because under section 142 and section 143, the provision is made for private undertakers to fix charges. That's their statutory provision to fix and demand charges. And section 143 sets out the contents of what may be included within a charges scheme, and that these provisions are enforceable under section 18 as well. So there is a statutory framework which regulates the fixing of charges. Then if we can come on to section 18, of course I'll come back to it in more detail when we make detailed submissions. It's a point which my learned friend has taken some, it's a section on which my learned friend has taken some time. The court's seen that under subsection 1, enforcement orders are available where an undertaker contravenes a condition of appointment or is likely to do so.
Can you just give us the page?
Oh, I'm so sorry, 694. So on the face of it, where the regulator is satisfied there's a breach, there shall be a final or a provisional enforcement order, and we'll come on to the exceptions in a moment. Looking at subsection 3, in determining whether or not it's requisite to make a provisional enforcement order, regard is to be had to the extent to which any person is likely to sustain loss or damage in consequence of the contravention. So at this stage, the interests of persons likely to be harmed is immediately brought into play in deciding whether enforcement will be final or provisional. Then section, and of course if the regulator fails properly to take into account such harm, any decision will be susceptible to judicial review. Then at section 18.8, we have a provision which doesn't get any easier the more times one reads it. You've seen what we say in our case, and perhaps I can summarise 3 points which I draw particular attention. It's common ground that the mere fact that a state of affairs gives rise to a remedy under section 18 does not mean automatically that any other remedy is arising from that state of affairs is excluded. Secondly, the important focus we respectfully submit in this section is on remedies rather than framing the exclusion by reference to causes of action. And thirdly, picking up the point that Lord Justice Nugee made at paragraph 53 of his judgment on page 216, I don't think we need turn it up, is that the section doesn't actually tell us directly about what other remedies may be available. To understand availability, we say, following Marchich, one needs to look at the scheme of the Act as a whole. We'll come back to that when we make our submissions on Marchich.
What is your point, your second point? The important focus is on remedies rather than causes of action.
Well,
we're going to come back to what that means.
The reason I make that submission, of course, is that my learned friend Mr. Hockman puts his case on the basis that Marchich is about the cause of action in nuisance rather than the exclusion of remedy. We say the focus on remedy, where in this case, and indeed in the Marchich case, however one framed the cause of action, in essence, we say in this case, the claim was for a breach of section 94, and we say the reasoning in Marchich is that because section 18 provides a remedial regime for the remedy of that breach, it is common law remedies that are excluded, however one frames the cause of action. If the remedy is one which conflicts with the statutory discretion, or discretion is not the right, but the statutory duties of the regulator.
We'll just look at that in a little bit more detail. In subsection 8, we're told, after A and B, we're told the only remedies, apart from those available by virtue of this section, shall be those to which express provision is made by or under any enactment, and those that are available otherwise than by virtue of its constituting a contravention of the statutory appointment or license condition, or of a requirement of this statute enforceable under section 18. Now, given that we have, well, first of all, any remedies for which express provision is made by or under any enactment, what do you say the remainder there is referring to, the phrase about those that are available otherwise?
So, this is where we get into, for instance, the discussion in Dobson, to which I'll come. If
you're going to come to it,
yeah, I will.
Well, in that case, I'll be patient.
Yeah, I'm right. We say Dobson, in essence, explains in practice how this works out. But the essence of the point is this: where something fairly and squarely amounts to a breach of Section 94, and the remedy for that breach amounts to something which overlaps to an extent that it conflicts effectively with the judgments that have to be exercised by Ofwat, then that remedy isn't available. But there will be other areas where, for instance, in a case of negligence, where one's not looking at the need for the provision of new infrastructure or the balancing exercise, and that sort of case. Where one of our operatives accidentally spills toxic material into our system, that sort of situation, when there's no overlap, there's no conflict with what the regulator has to do. So in that sort of situation, the common law action can remain. And that is where the common law action is available, or another action is available.
So you're heavily, sorry, I realise you're going to come back to this, but as you've sort of started it, you're focusing a lot on the word available.
Yes. I think. Yeah.
Am I right in understanding? I mean, we had a very clear exposition by Mr. de la Mare as to how this works, where he split it into two, if you recall, and in effect said breach of statutory duty. Well, leaving aside the first part, express provision is made under any enactment. We were then dealing with situations where you have to effectively rely on the breach of statutory duty in order to create the cause of action.
In that,
the second part.
Yeah,
now,
exactly.
Do you accept that approach of Mr. de la Mare subject to the word available?
Well, if I understand the point your Lordship is putting to me, to be within, for present purposes, we are looking at Section 94. For this provision to be engaged, we are hypothesising that Section 94 has been breached. So the question then is, what is the remedy? This is picking up my lady's point, focuses on remedy. What is the remedy for that breach? If the nature of the breach and the remedy for that breach is one which in practice conflicts with the judgments, or may conflict with the judgments of the regulator, then it is a matter for which the only remedy is that provided by the section. If, however, there is a breach of the Section 94 duty, the remedy for which does not so conflict, and one may see that in the case of negligence, no question of additional infrastructure needing to be provided. There isn't a conflict of that with the remedial regime, so as we see in Dobson in due course, those remedies are available.
Dobson is a different cause of action.
Oh, well...
what was being allowed, whereas what you seem to be suggesting, and there's some misunderstanding, is that it doesn't really matter what the cause of action is, it's what is the extent of what we would need to do to remedy it. So to take Mr. Marchich's unfortunate position, if on the facts he had been able to show, look, for £200 you could sort this, why don't you just do it, then he wouldn't have been barred. Well, because it's a kind of trivial amount of money, say, or whatever amount of money. Well, so I'm not quite sure if that's what you're saying, that it's not so much the cause of action, it's the extent of the expenditure that would be required?
No, I don't put it in terms of expenditure. I put it in terms of the judgment that has to be exercised. If, for instance, triviality is one of the matters which the regulator has to take into account in deciding on the remedial regime. So if it were trivial, that would be a matter well and truly within the regulator's remit, and it wouldn't be for the court. In fact, we would say, in particular, it wouldn't be for the court to deal with such matters.
So you're not looking at the remedies sought in a particular individual case, you're looking at it more generally.
Yes, we look at the nature of the exercise which the court has to undertake in a case. Is it an exercise which, under the statutory scheme, falls within the remit of the regulator? That's the way I put it. I hope I've clarified the point you're making to satisfaction.
And the other point was when you said that we're positing here that Section 94 is breached. Are you then saying it's because of that the distinction that Mr. de la Mare was trying to make between whether you're relying on a breach or not relying on a breach in pleading your cause of action is not the right distinction?
No, I agree. It's not the right distinction. But when we come to look at the way the House of Lords in Marchich considered the case as a matter of statutory construction, and the earlier authorities which the Court of Appeal relied on, the House of Lords relied on, both the Robinson case and the Parsonal case, one sees how the conflict with a remedial regime leads to the exclusion of a common law remedy, where common law cause of action, where the essence of the cause of action, substance of cause of action amounts to a breach, so that the remedy for that statutory breach is in the remit of the regulator.
Before we leave Section 18, subsection 8, could I just ask this? Do you accept Mr. de la Mare's submission that the categories of preserved actions, in the final words of subsection 8, lead you to 94.4 and in turn to section 117?
We do go to section 117, but section 117 does not, we say, have anything to do with causes of action.
So you'll come to that point.
I will be coming to section 117 and its role in the scheme. But section 117 does not, in our respectful submission, give a cause of action. It's simply about the limits of authority, and we accept it is part of our case that the sort of complaint which we are facing from the Canal Company is not authorised. The question is, what is the remedy for that lack of authorisation?
So the answer is that there's not a third category of preserved cause of action. Thank you.
I will briefly to deal with the Lancaster case, which my learned friend dealt with. That appears in the supplemental bundle at volume 2, tab 9, page 193. That case concerned a previous incarnation of section 2, subsection 3a, and that actually doesn't appear in the judgment, but it appears at page 1512, which is volume 3, tab 23, 1512. And one sees at the originally enacted section 2A, that there was a duty on the Secretary of State or the Director, in the manner that he considers is best calculated, to secure the functions of a water undertaker and a sewerage undertaker are properly carried out as respects every area of England and Wales. One sees at page 212 of the bundle in the Lancaster case, the supplemental bundle, the argument that was being framed in relation to that case, in relation to that section. It's the second main paragraph on that page, and it was effectively being said that the Director wishes to exercise a discretion to refrain from making enforcement orders, providing that he has powers to do so. And it was said that section 2.3a gave him powers to refrain from making enforcement orders. And it was that contention in relation to the previous form of duty that the judge at page 213, a passage to which my learned friend drew the court's attention, in my judgment, Mr. Howell is correct. It was that judgment, it was that argument which was rejected. It was held that there was no discretion under that version of the statute. We'll come on to it when we look at Marchage, but we say that this tells us nothing about the exercise which the regulator must undertake when duties under section 2 may conflict when deciding when, how, and indeed whether enforcement should be taken under section 18, which is the exercise which underpinned Lord Nichols's judgment, and which, of course, that his speech setting out that judgment was sometime after this case. But we say this case takes matters no further in relation to Marchage. But since it was referred to, I deal with it now in that way, to say that it has no bearing on the exercise which Lord Nichols was considering. If I can come on to section 22, which is at page 705 of the bundle, that provides for remedies in the event of non-compliance. The court's seen that provision, but I do draw attention to section 22, subsection 2, which provides the breach of cause of action for breach of statutory duty.
I'm awfully sorry. Could you just give me the page number again?
Sorry, page 705.
Thank you very much.
Section 22.2 is the provision which provides that there's a cause of action, breach of statutory duty, where persons have sustained loss or damage. And it is, in my submission, relevant to note that there is a defence of taking all reasonable steps and exercising due diligence. And that defence, on the face of it, is in conflict with what is probably the most obvious cause of action for escapes from sewers, namely Rylands and Fletcher. It is an escape from a sewer is something which may reasonably be contemplated. It's a dangerous non-natural use of land within the notion of Rylands and Fletcher, and when that goes on, at common law, taking reasonable steps to prevent the escape would provide no defence. So we have a conflict here with the common law in the remedial regime. We'll come back more generally, but that is a specific point. And at section 22A, we see that Ofwat has powers to impose financial penalties, and that's on 706, and I needn't take the court to that. The next point is to look at is section 94.1. The court has already seen that. There are two limbs in section 94.1. It's on page 726 of the bundle. Section 94.2 deals with trade effluent with which we're not concerned. Section 94.3 deals with the general duties of sewerage undertakers and makes them enforceable under section 18.
Just thinking about the point you've just made, I suppose it could be said that the scope of the statutory duty created by section 22.1 is very wide. It's owed to any person who may be affected. If on the hypothesis that a right of action lay in nuisance or trespass, the scope of that would be narrower. It wouldn't be enough to show that you were affected.
That is right, but the breach of statutory duty, A, in some respects is wider, but B, in other respects is narrower. They don't sit easily together. It's the short point that I made.
Yes, the point I'm putting to you really is that they're not inconsistent in that you could have a wide duty to which there was a defence, as we see in subsection 3, at the same time as the common law imposed a duty that was much narrower in scope to property owners, which lacked a similarly generous defence.
I'd accept in theory if this were looked at in isolation, that is we submit something which follows. However, our general point is one needs to look at it as a whole, and we see in this case, certainly in relation to the way the Manchester Ship Canal would frame its case against us, there is at least, on the face of it, a potential conflict between the two regimes. But your lordship is absolutely right. They're viewed in isolation. In theory, it could be possible.
Although section 22 subsection 1 is drafted very broadly, who may be affected by it, in subsection 2 it's only actionable by people who have suffered loss and damage.
Yes, it's only trespass strictly so called wouldn't come into play. It's envisaging under the statutory regime that those who suffer loss and damage will have the claim rather than those.
That claim can be met, even if they've suffered loss and damage. It can be met by a defence that all reasonable endeavours were.
Yes, that's absolutely right.
As you mentioned, Rylands and Fletcher, what's been the position in this litigation with Rylands and Fletcher?
Well, they haven't suggested that Rylands and Fletcher apply. They being the Manchester Ship Canal Company, have put their case purely on the basis of trespass. Now that will come on you. No, their case in the 2010 litigation has always been trespass. Our case is that it is, on the face of it, more likely to be a nuisance. And in fact, we say it is a nuisance. We say it's fact specific as well.
But we're being asked at the moment to look at
both.
Nuisance and trespass.
Exactly.
What I'm now asking you is, are we actually, within the umbrella head of nuisance, also looking at Rylands and Fletcher?
Indeed, that's what we say. We say we put the
nuisance is embracing
Rylands and Fletcher is a category, is a sort of nuisance. As one sees from the Cambridge case.
Thank you.
though historically it is sometimes referred to as a form of trespass. The modern law makes it quite clear that we're in the law of nuisance. We're on section 94. Section 94 on page 726. I'd referred to section 94.3. Section 94.4 makes it clear that where there are other provisions which create duties, they're separately enforceable. There are a number of duties in the provisions which follows, express duties. For instance, one sees section 98.4 on page 749. My learned friend says, I hear him say obligations. Quite right, it's obligations. One sees an express obligation under section 98.4 on page 749. Section 98 being the provision of the duty to comply with a sewer requisition, and then where a duty is owed, any breach of that duty shall be actionable. So that is an example of the obligation within the scope of section 94.4. We'll come back to whether the provisos create separate obligations in due course, and we say they don't. That provision is supplemented by Regulation 4 of the Urban Wastewater Treatment Regulations. My learned friend referred you to those. We've dealt with that in our case at pages 170 to 171, at paragraph 5. I don't propose to take the court to that. Section 95 on page 737, we respectfully submit, is important. There are a number of points which we say my learned friend isn't correct about in the way he described the provision. The court has read section 95.1. Section 95.2 empowers the Secretary of State to make regulations that prescribe standards of performance in relation to the provision of sewerage services. Sewerage services are defined in section 2191 on page 961. These include the disposal of sewage and any other services which are required to be provided by a sewerage undertaker for the purposes of carrying out its functions. And looking at the wording of section 95.2, in the standards are to be provided in connection with those services as ought to be achieved in individual cases. It's not talking about cases of individuals or customers, it's talking about individual cases. We're talking about categories of case to which these standards may be prescribed. Then section 95.3 provides for a financial remedy, and there are 2 points to make there. The regulations may make provision for such financial amount to be paid to any person, not any customer, any person. Affected by the failure to meet the duty. Now, it is true that the current regulations, which remedy the marchage problem, on the face of it, look as though they deal with consumers. But this provision is far wider than that. And there's another point to pick up. My learned friends suggested that the regulations allow simply for a fixed sum. That's not quite accurate, we'd respectfully submit, because the provision is for a prescribed amount, and there is nothing in principle to prevent the Secretary of State providing for that amounts to be ascertained by reference to a formula. That's a small point. We don't know how the Secretary of State would work it out in this case, but it's not simply a matter of a prescribed of a fixed sum.
At 95(1)(b), it refers to supplementing the duty. So is it the case that you can establish overall standards of performance in relation to aspects of the supply which would not be in breach of the general duty, but still set financial compensation for a failure to comply with the standard, even though that failure didn't amount to a breach of Section 94?
I'm being tugged at. From Mr. McCreth points out that subsection B only applies to contraventions of the requirements as may be prescribed to be treated for the purpose of that as breaches of that duty. That's the limitation. But in principle, they go wider than simply a breach of Section 94, if that's what your ladyship is getting at. But we say, because of the wide definition of sewerage services, which include the disposal of sewage, breaches of the Section 94 duty are within the scope of this wide provision. And where any person is affected by that failure, the Secretary of State may make a remedy. He hasn't yet, but we say, in principle, he could. And one sees the way it was dealt with by Lord Nichols in March. The absence of one was noted in March, and subsequently the Secretary of State made provision. The current regulations, which provides for modest amounts to be paid for people in Mr. March's provisions, are on pages, the relevant clauses are on pages 4534 and 4535. I needn't take the courts to them. They don't apply here. But it is relevant to note that in making regulations under Section 94 in accordance with the procedures referred to in Section 96, the Secretary of State is under obligations, as we've seen in Section 2. So in fixing the amount, he will consider the interests of consumers, but also the other duties in relation, for instance, to returns on capital. So here, in the provision of a regulation, this provision, whether one should be applied and how it should be applied, it's a matter for the Secretary of State exercising his duties under Section 2 to make a decision. My learner from Mr. Delamere took the court to Section 98, which I briefly referred, Section 106 and Section 116, and I don't propose to take the court to those who the court got the point about their nature. We now come to the provisos, which I'll take relatively quickly because we will come back to this under our sixth proposition. Section 1175 on page 229, as was pointed out yesterday, it is. I'm so sorry. That's not right. 860. I don't know where. It's in an interpretation provision, as my lady pointed out yesterday. It's framed, indeed, as a provision relating to the construction of a statute. And there are two limbs, as the court has seen, environmental protection legislation and prejudicial effect of water quality. And we say, in essence, this is simply a provision, we'll come back to this, which makes clear that there is a lack of authorisation under the provisions referred to for discharges which prejudicially affect water quality. And I'll come on to the way this provision was considered by the House of Lords in the 2014 litigation, the way Lord Sumption dealt with it. And I respectfully, or will respectfully submit when I come on to that case, that it is not OTOs or gobbledygook or gibberish, I think, to use my learned friend's phrase. It does have an important function, because as we'll see, the way Lord Sumption put it, without such a provision, sewerage undertakers would be authorised to pollute. And you'll see that he puts it in express terms when he deals with the BWB case. We'll look at that when I come back to the 2014 case. Section 117(6) is in terms which imposes a duty, and it suggests on its face that claims for nuisance might remain. At first instance, and in the Court of Appeal, at any rate, it was common ground that nuisance in this context means nuisance resulting from negligence. I think my learned friend yesterday didn't adopt that position. However, there is authority, direct authority, for how the predecessor of this provision was construed in the bundle at page 3886, the Smeaton case. It's in volume 11, tab 107 for those on the paper versions, and the report starts at 3886. The relevant passage is at 3913. Mr. Justice Upjohn says, I turn then to the relevant statutory provisions. He refers to them, and he refers to the provision then in section 31 of the 1936 Act. Local authorities shall so discharge their functions under the foregoing provisions of this Act as not to create a nuisance. So we're dealing with a statutory predecessor to the current provision. That section necessarily implies, in my judgment, that provided the defendant corporation does not create a nuisance in carrying out duties, it is absolved from liability. What then does the section mean by not to create a nuisance? As far as this court is concerned, it must be taken as settled that the proper construction to be given to the section is to exclude liability for escapes in the absence of negligence, and therefore to negative the rule in Rylands and Fletcher, and he refers to earlier cases. That is the basis on which it was argued below, and we say, if and to the extent that Malone resiles from that proposition, we adopt this as strong indication for how this provision should be construed when it was reenacted in the same form in the 91 Act. And of course, it is consistent with the different statutory scheme and the way it was interpreted in Allen and Gulf Oil, which is in the bundle. We don't need to turn to it at 1787, and Smeaton, although not referred to in the judgments, was cited in that case. It is in the list of cases cited but not referred to in the judgment. That's why we say.
Can you just explain why it is that nuisance is read as containing the concept of negligence?
Well, in my submission, what it is dealing with is a similar situation to that suggested in Allen and Gulf Oil. What one is dealing with is that which is authorised generally. And the question is, what is the exception from that authorisation? What is Parliament intending should be accepted? And in order, if something without negligence causes harm, it is difficult to square with a general authorisation. However, Parliament cannot have intended to exclude that which is negligence in the performance of that which is otherwise authorised. And that's one sees in different contexts, put slightly differently in Allen and Gulf Oil, and this is the way the statutory predecessor to this section was taken as being settled. Now, of course, we are dealing with a new chapter, but I respectfully submit this is persuasive.
How does that tie in with the argument about we don't want to impose duties in relation to failures to provide infrastructure?
Well, we say it's entirely consistent with the way we put it and the way Dobson works, because of course Dobson, when we come to it, we say does exclude that situation where there is a negligent performance from the side. Well, exclude is the wrong way to put it.
Well, can I just put to you what's just concerning me? We know from, I think, cases like Allen and Gulf Oil that we have a distinction in negligence between what you might call the operational and the policy side.
Yeah.
So that one understands that negligence in relation to the policy side ties in with not providing the infrastructure that you might say. But say we have the other type of negligence in issue, a negligent failure in some sense to operate the system. Why should that also be embraced by equating nuisance and negligence?
Well, going back to the point I was making, what this provision does is qualify other provisions in the Act which authorise activities. So it's providing a limit on authorisation. So the question then is, what activities did Parliament intend to limit? As a matter of statutory construction, consistently with the distinction we make between policy, non-negligent, the policy matters and matters of negligence outside policy, we say that is a distinction which can properly be inferred, because, as I've indicated, Parliament, when authorising activities, won't easily be taken as authorising negligent activities. However, in authorising an activity, it is unlikely, or there would be a conflict if that which was authorised could not be undertaken regardless of negligence.
I suppose what I'm putting to you is the distinction in Allen and Gulf Oil is obviously after Smeaton.
Yes.
Smeaton doesn't talk about any distinctions within negligence.
No.
It just says negligence
Yes.
across the board. So can we, in a sense, you seem to me, with respect, to be looking back from the Allen and Guilfoyle and saying, oh, it's all very consistent because Smeaton has always been saying that. That's my problem.
Yeah, your lordship's right. Perhaps we should take it in stages. This case obviously predates Allen and Guilfoyle. It is a provision. It is a case directly concerning how this a provision in the same form as this provision is to be construed. So it is, we submit, at the very least, persuasive on how this provision should still be construed, albeit that we're dealing with a new chapter. And I think I may have overstated when I refer to Allen and Guilfoyle. All I say is that subsequently and prior to this legislation, we have the Allen and Guilfoyle decision, which is consistent, we say, with this conclusion, though a different statutory regime. And therefore, when one comes to look at the Water Industry Act 1991, we have directly Smeaton and the cases referred to in Smeaton, and subsequently Allen and Guilfoyle, which Smeaton was cited, which doesn't undermine that general proposition. That's the only reason I refer to Allen and Guilfoyle. There's a consistency in the jurisprudence prior to the enactment of the 1991 legislation. Does that answer your lordship's question? I probably took it rather too quickly.
Well, I hear what you say. Let's put it that way.
But I can move on. I'm obliged. Then we have section 186, which is at page 952. We'll come back to that in due course, but like section 1175, we say it doesn't, in express terms, tell us what the consequences of a failure to comply with the proviso are. The section isn't limited simply to, it goes far wider than outfalls and into watercourses, and it obviously covers matters significantly beyond pollution of watercourse. So, for instance, if a sewerage undertaker constructs works which deprive a watercourse owner of the flow of water, that would be included. That would potentially be an injurious affection. If a sewerage undertaker discharges effluent which is treated, it disposes of the sewage effectually, but downstream erosion is caused, that would be included. So it is far wider than anything which might form a breach, the sort of discharge with which we're concerned here. I'll come back to that when I make my sixth submission. At this point, I'm conscious that time is running on. I should take the court to section 141A, which is at page 908, I believe, the bundle. 905 it starts, I'm sorry, it starts at 905. I'll take this quickly, but in essence, the Secretary of State is required to produce a plan for the purposes of reducing discharges from the storm overflow of sewerage undertakers whose area is wholly or mainly in England, and reducing the adverse impacts of those discharges. So we have legislation which fairly and squarely covers at least the problem which gives rise to the Manchester Ship Canals Company's potential complaint. Sewerage undertakers are required to report annually. I'll take this quickly. That's at section 141C, at page 908, and the Secretary of State himself must report to Parliament, section 141B, page 908. Then section 141DA, undertakers then have obligations to publish information. That's page 911, and that is enforceable. These provisions, to the extent that they're duties of sewerage undertakers, are enforceable under section 18. Section 141DC, which is at page 915, is, in my respectful submission, significant. It indicates that a sewerage undertaker whose area is wholly or mainly in England must secure a progressive reduction in the adverse impact of discharges from the undertaker's storm overflows. So one's looking at Parliament separately from the section 94 duty, envisaging a progressive reduction in impacts from discharges.
Sorry, what page?
It's at page 915,
Thank you.
section 141, capital D, capital C. Sewerage undertaker whose area is wholly or mainly in England must secure a progressive reduction in the adverse impact of discharge from the undertaker's storm overflows.
Have these provisions been brought into force?
They are in force. So they've been brought into force since the Court of Appeal hearing. So this is the statutory regime which is now in force. So, I'm so sorry. DC is not yet in force. I'm so sorry, but we'll see the plan in due course, because the plan has been published. Yeah, section 141A is in force. The plan has been published. So the next step is for this. And if I can turn now to the plan, this is at tab 13, volume 13, tab 132, at page 4317. It starts at four. I'm so sorry.
This is an old document.
It is 437.
4373. It starts at, yes, the title page is 4371. Oh, sorry, I'm so sorry. It is 43773. So sorry. I'll simply ask the court to note the following pages. I won't take the court to them at length. 4377 is the foreword by the minister. There's an emphasis there on water bills amongst other things. It refers to this being the largest infrastructure project to restore the environment. 4381 sets out the environmental target. The point there is that the plan envisages a reduction by date in the future. So there'll be a progressive reduction until then, but the targets are future dated, the objective. And one sees there at page 4382 similar future dated objectives in relation to the bathing water target, and similarly in relation to the heavy rainfall target on page 4382. 4383 expressly refers to investment cycles, at paragraph 2.3. And 4384 is significant if one's looking at the practical implementation of improvements. The first main paragraph: we do not have evidence at this stage to fully predict whether individual water companies can go faster to achieve the targets in the 2030s and beyond. The upgrades will require significant increases in supply chain capacity, from skills to equipment. It's probably worth, for what it's worth, if one looks at 4385, one sees a pie chart of costs by customer base of the improvements, and one sees that United Utilities customers are going to bear quite a lot of the costs. Perhaps not surprising, we are in a very rainy part of the world where there's a lot of brownfield development which requires there are a lot of brownfield sites which require to be connected to the existing infrastructure. The regulators are, and their role in this is set out in section 3.7 on page 4397. Roles of Ofwat and the Environment Agency referred to. Then at and it's envisaged at 4398 that it'll be Ofwat that has enforcement powers to ensure compliance with statutory obligations. It's predicated on it being Ofwat that will secure compliance with the plan. I won't take up the court's further time on this, but one sees the direction of travel, if one can call it that, of how the problem is envisaged as being remedied through the current statutory process.
I see that Ofwat is referred to as the independent economic regulator on
Yes.
that page.
And then the Environment Agency obviously is the environmental regulator, but as we've seen under section 3, the economic regulator is not immune from environmental concerns, and of course, as you will have picked up, certainly there is case law at first instance which shows that the Environmental Act and the 1991 Industry Act are read, can be and should be read together, and in practice they are. One's seen the references to the open challenge process by which the regulator, the undertakers, or the regulators and the undertakers formulate future plans. And this is the case. It's an appropriate place to take up the Bowden case, which is at page 2008 of the bundle, volume 5.
Page 2008.
Page 2008, volume 5, tab 40. That was a case of mussel fishermen who brought various common law claims as well as claims for breaches of statutory duty. Won't detain the court long with this case. I refer the court first of all to page 217, where Mr. Justice Carnworth, as he then was, 217 to 218, sets out a passage from an earlier judgment of Mr. Justice Harrison. 2017. I'm sorry, I'm going too quickly for myself. 2017. One sees the different authorities being described as a seamless web. And the reference to the NRA, which is now the Environment Agency. And then over the page, top 2018, the role of the director. Since we've got the case open, the director, of course, being Ofwat, since we've got the case open, Mr. Justice Carnworth at page 2021 makes a number of general comments on these provisions, which are relevant not only to the point about a seamless web and how the statutes should be read together, but he makes a number of points at 2021 to 2012. 2021, I'm so sorry. The first is a point. He makes the point that it's obvious. Some general if obvious comments on the plaintiff's case in respect of these provisions is appropriate. First, in those cases where statute specifically says that there shall be no civil remedy, it means what it says, and we entertain the court with that. Secondly, and this is where he refers to the section 1175 proviso. In those cases where the statutory provision is a saving clause, it cannot be relied on as creating an independent cause of action. So there is no positive duty imposed as a result of the section 1175. Thus, section 1175 does no more than make clear that the provisions to which it refers do not create any statutory immunity from liability for actions referred to in paragraphs A and B. Though, of course, he wasn't considering the question here, and which was considered in March, what the consequences of the breach would be and where the remedy for the breach would lie. Thirdly, he points there are a number of provisions which expressly confer a cause of action in damages, and we've seen, for instance, section 98, but we need to look at that. And then over the page, 2022, generally the provisions of the WIA and WRA constitute an elaborate regulatory code analogous to the social welfare legislation reviewed in X. So we say this is an indication of how the regulatory, the financial regulatory and the environmental regulatory regime should be read together.
Just clarify that he struck out all the claims apart from the common law.
Yeah, and my learned friend has reminded me, Mr. Justice Conworth struck out all the claims based on statutory breach of statutory duty and allowed the common law claims to proceed, but of course he was not considering the case, the case here, and it is not. We say it takes the matter no further until one reaches March. If I can take propositions 4 and 5 together, I'm going to make 5 submissions. Proposition 4 being that the common law claims would conflict with the regulatory regime, part of being Parliament's intention that those claims, sort we're looking at here, would survive. And proposition 5 is confirmed by March. And there are 5 submissions I would make. The first is that prior to March, it was well established that when a special or qualified statutory remedy is provided for the breach of a statutory duty, it could be inferred that Parliament intended to exclude any common law remedy which would or might have arisen from the same facts. And for that proposition, I refer to the 2 cases referred to in the judgment of Lord Nichols, namely Robinson and Workington, and Passmore and Oswald Whistle Council. The second submission is that it is this principle which was extended and applied by both Lord Nichols and Lord Hoffman in Marchich. Mr. Marchich's claim being in essence one which amounted to a claim that a sewerage undertaker had failed to build enough sewers in breach of the Section 94 duty. And because, however, Mr. Marchich dressed the case up, it was a breach of duty which brought it within Section 18, which was inconsistent with the claim as brought by Mr. Marchich. The third submission I make is that this principle was applied, as applied in Marchich, was confirmed by subsequent cases in Deutsche Grenfell, Total and CPAG. Fourthly, we say this analysis doesn't mean that there's a complete ouster of all common law remedies, and this is where we refer to Dobson. And finally, we say applying the principle to this case, the sort of claim being intimated, threatened by Manchester Ship Canal Company is excluded from the courts and must be dealt with by complaint to the regulator. So submission 1 is the effect of Robinson and Workington and Passmore and Oswald Whistle. Robinson appears at page 3696, volume 10. Tab 100 for those on paper volumes. In the text, it tells us the nature of the action. The text below the headnote, this was an action to recover damages for injuries. It's a case where initially there was an adequate sewer and subsequently became inadequate due to subsequent connections, and the facts are described as I've indicated there. Lord Isha, the master of the rolls, well, the court as a whole held there was no claim, but the proper remedy was under section 299 of the Act. The claim was framed, was in essence a claim of a breach of statutory duty, so it's different to the claim as framed in Marchich, but we'll see, as I've indicated, how the House of Lords in Marchich considered this case. 3697, Lord Isha's judgment starts. He said the first thing to consider is what is the complaint, and he deals with the complaint on page 3698. He says the real complaint is that the defendant has not caused to be made such sewers as are necessary for effectively draining their district. Whether has been suggested this obligation relates to sewers for draining the whole district, I do not say. But assuming that the case can be brought within section 15 of the Act and the defendants are in default, that is an act of non-feasance on their part, not an act of misfeasance. So we see the old advanced distinction between misfeasance and misfeasance and non-feasance. He goes on to say if it were not for the statute, there would be no duty on the defendants to do anything in the matter, and a default on their part is dealt with by a remedy provided by the same statute. I have no hesitation in saying that is the only remedy which is available. And then he says it's been laid out for many years that if a duty is imposed by statute, but for the statute would not exist, and a remedy for default of breach of that duty is provided by the statute, that creates a duty that is the only remedy.
Yeah, but this reasoning, as far as it goes, this reasoning wouldn't apply to conduct which created a nuisance.
Well,
the issue here was a failure to drain, and he's obviously Lord Isha's quite right. If it weren't for the statute, no duty on the defendant to do anything.
Okay, I take your lordship's point entirely. But can I?
Yes, it says that, if a duty is imposed by statute, which but for the statute wouldn't exist, then the statutory remedy is the only remedy.
Quite so. Can I park? I use the phrase your lordship's concern, and your lordship is quite right to raise that point, and wait until we look at the way the Court of Appeal, the House of Lords rather in Marchich dealt with this, and indeed how Lord Hoffman subsequently referred to the Marchich Bridge Mill in Deutsche Morgan, and just remember the way it's put here, and that's why I use when I referred to these cases in Marchich, I said applied and extended. So Marchich goes a bit further. But we also see on page 3699 how Lord Justice, I'm never sure whether his name is Lopez or Lopes, but we see the way that
I think Lopes.
Lopes. I thought it was Lopes, but I've heard others. I'll go with your lordship's ruling on that.
Well, it's not quite De Kaiser.
If one looks about 2/3 of the way down, he says, I think, speaking only for myself, that independently of any express provisions of the Act of Parliament, there will be no right of action. But when we find in the same Act of Parliament, which creates a duty, a remedy given for non-feasance, it is abundantly clear to my mind that there can be no action by an individual on special remedies given by section 299. So again, he's approaching it as a matter of statutory construction, though he does accept that if he were dealing with it himself, he would deal with it by reference to the common law. And then we have a similar approach in Lord Justice Chitty.
Well, no, his approach is exactly the same as Lord Isher's.
Yes. Yes, I accept that entirely. That's my point. We have, as I've indicated, we'll see the way Lord Nichols and indeed Lord Hoffman use this as a springboard for their reasoning of statutory interpretation in March. I refer to it simply because it does provide the starting point for their reasoning, both of them. And then we see a similar point on page 3700 over to page 3701 in Lord Justice Chitty's approach. And I'm happy to accept your Lordship's caveat as to the state of the jurisprudence at this stage. Then we see Passmore, which is a different sort of case. That is in volume 8, at tab 81, where the claim wasn't framed in nuisance. It was a claim for mandamus.
That's a page.
Page 3144. As I've indicated, that was a claim for mandamus requiring the building of sewers in accordance with the duty under section 15 of the 1875 Act. It was held that there was no common law claim available because the remedy is under statute. And again, one sees the way it was dealt with, and we'll see it finds its way into the reasoning in the judgment of Lord Nichols. And again, the wording has echoes of what Lord Hoffman says in Deutsche. At page 3151, they hold that there's no claim for mandamus, and just over halfway down, Lord Halsbury says the principle that where a specific remedy is given by statute is that it therefore deprives the person who insists upon a remedy of any other form of remedy than that given by the statute is one which is very familiar and which runs through the law. And it may sound like a relatively trite proposition, but it is the springboard, we say, for the reasoning of Lord Nichols, and finds its way, echoes of the language in the way that Lord Hoffman put it in the Deutsche case.
If you read on, I think the reasoning is the same as in the earlier case. He quotes Lord Tenterden, where an act creates an obligation.
Yes.
And then he says the obligation which is created by this statute is an obligation which is created by the statute and by the statute alone.
And of course, when we come to the way Lord Nichols reasons in Marchage, he says yes, there is an obligation under the statute, under section 94. And however one dresses up the common law claim, it comes down in substance to a claim coincident with the breach, glossing what Nichols said, with the breach of section 94. And he uses this as the springboard for his approach in Marchage to say, well, the claim, even if dressed up as a claim for nuisance, as a common law claim, in essence, it is a claim for a breach which falls within section 18. I'll come to Marchage now, but it is, as we see, I respectfully submit, the starting point of the reasoning. So we can turn up Marchage. As I say, I respectfully submit the House of Lords in Marchage extend this reasoning. They see it as a principle. Firstly, we get from this a principle of statutory construction, and then they take the point a step further, having regard to the complex statutory regime that we're considering under the 1991 Act. And
I see Lord Macnaghten page, I don't know what the first numeral is, but 155 are the last three digits. Lord McNaughton says about two-thirds of the way down the page, the real answer to counsel Mr. Cousin-Hardy's argument is that the obligation was never more than a statutory obligation. It didn't exist at common law.
Yes, as I've indicated, your lordship's understanding of the limits of this reasoning, I don't shy away from that. But the important point to take from this is that what they are doing here is construing a statute, and the exercise of statutory construction is then used by Lord Nichols and Lord Hoffman to exclude the claim in March.
But in a, in a context where the ratio of the earlier cases doesn't apply.
Well, that's why I say they extend it. The way they put it, because they're looking at a more complex statutory regime, and they look at as a question of interpretation of that statute, where the claim in substance, while dressed up as a common law claim, amounts to a breach of duty, which is inconsistent with the regulatory regime provided by the Act. They then exclude it. So they're extending that reasoning. But the essence of what is going on here is A, that it's a question of statutory construction, and B, the extent to which a common law claim remains is to be decided by that principle. And that's why I say it's the springboard from which the reasoning in Marchich.
I mean, the difficulty with that is that we also know that there's an important legislative interpretative principle which has been referred to as the principle of legality.
I'm sorry to interrupt.
All I was going to say was that the passages you've shown us are not inconsistent with that.
Yes. And I'm not going to shy away from the principle of legality, and indeed I say it was dealt with headlong, or head-on rather, in Marchich through the analysis of whether or not the statutory regime was consistent with the Human Rights Act, because I'll be making this submission in due course. The principle of legality has, in substance or in effect, been subsumed into considerations under Section 3 of the Human Rights Act. I've been looking at that, and you're familiar with the cases. We're looking at that.
It's a completely different rule. The Human Rights Act gives a highly qualified protection to property rights in A1P1, but the rule of statutory interpretation that a statute is not construed as depriving a person of their property unless that's express or the necessary implication. That's a much older and separate rule, which goes back at least as far as Entick and Carrington.
If that is understood as the principle of legality, I don't shy away from that either, because we say it's a matter of necessary implication in the way considered in March. It's not necessary linguistic implication, but a matter of necessary implication. I don't shy away from that. But my learned friend referred to the principle of legality as described in Sims, and I'll take the court very quickly to it. But in the case of A and Her Majesty's Treasury, there are certainly dicta, a clear indication that in practice the principle of legality as considered in Sims, which is the case to which my learned friend referred in argument, there has been a subsuming. But I don't shy away from the general proposition, and that was actually considered directly as the approach to statutory construction was considered directly in the CPAG case.
Even the principle in ex parte Pearson, ex parte Sims, and so forth. Certainly in the Unison case in this court was treated as a common law principle which was used to resolve that appeal, quite entirely distinctly from any European Convention of Human Rights issues.
As I say, if the principle of legality is considered in the way your lordship put it as a question effectively of construction, we say there's nothing inconsistent in that principle with the way it was dealt with, both in Marchich and indeed as subsequently dealt with in the run of cases to which we have referred.
Yes, because I mean, in Pearson, for example, that predates the Human Rights Act.
Yeah, well, yes, but if one looks at the way it's put in Sims, just for so it's not a point that I submit makes a difference to the way I put my case. But since the case was put on the principle of legality as described in Sims, that's the only reason I refer to Her Majesty's Treasury, where there is an express indication of this level, or as a high. There's an express indication that there is this subsuming, but I don't need this that's to be resolved in this case.
You say it's necessarily implied that it's excluded.
Quite so. And whether or not one needs to look at the principle of legality, or whether one needs to look at the Human Rights Act, the result is essentially the same. Dealing with Marchich, I can deal with it relatively quickly, but the court hasn't been taken to it, so I will, in detail, so I will take the court through what I say is the structure of the case.
Well, that does seem rather important, given that
Well,
we've been invited to depart.
Well, one might have thought the court would have seen a bit more of it, but I hope I will give the court slightly more of a flavour of the case. It starts at page 1122. I won't read the head note or go into detail. I will about the fact or background. I do draw attention to the way the case was being put by Mr. Sumption, as he then was, at page 1125, and he, at just below C, paragraph starting since privatisation, he deals with it, and I'll ask the court to sideline it, I won't read it out at length. He tells that the effect of the statutory scheme he's playing, he's putting this on the basis of the statutory scheme, and the way he puts it just below E, that scheme is not consistent with the existence of a right of action in tort against a sewerage undertaker for failing to enlarge the sewerage network in the area.
The next paragraph.
Yeah, don't worry, I'll come to it. If such a duty existed, it would be actionable whenever the undertaker failed to perform his statutory duty. And then we look at section 18.8. It says it preserves any right of action to which the claimant may be entitled to account for some breach of duty otherwise than by virtue of a breach constituting a contravention of the Act. It does not acknowledge that any such right of action exists. That's my point. Whether it exists is a question of policy to which the statutory scheme is directly relevant. The non-existence of a right of action for breach of statutory duty is a powerful point to the absence of a right of action of common law for substantially the same thing under a different legal label, and that's essentially the sort of case I'm putting to the court on section 18.8. Then, if I can take the court to the way Mr. Sumption put it in reply at 1129D to E, the statutory scheme is a response to the problem, which is described. The benefit of having a regulator is that he can make decisions with a broad view of the implications for all parties concerned. That is precisely how such a scheme ought to work. The decisions, depending on general considerations affecting the community at large, are not suitable for a court. So he's not putting the case there on the basis, as my learned friend Mr. Hoffman put it. He's not putting it on the basis of precise causes of action, he's putting it on a far wider basis. So that's the way it was put to the court. Then we come to the judgment of Lord Nichols, which starts on page 1129. I'll give the headline points of what I say the structure of the judgment is. At 1129 to 130, paragraphs 1 to 3, he describes the nature of sewer flooding. And how sewers and drains which were sufficient are no longer sufficient. We say to that extent the problem is an analogous problem to the one we have. It deals more specifically with the facts, and at paragraph 7, just below B, he says, we say analogous to our facts, the only effective solution is enlarging or extending the existing public sewerage system. New public surface water sewers are needed to provide additional capacity to cope with heavy rainfall. So again, analogous to us. Then, paragraph 10, he starts dealing with the statutory scheme. He sets out matters of background. Again, I won't need to read it. Going on to paragraphs 15 to 16, he deals with the practical exercise of the directors of the director now Ofwat in decision making under section 19. Then he goes on to deal with the other statutory provisions, 18, 22. And then he refers at paragraph 18 to...
I don't know if it's worth mentioning, but since we've been taken to the judgment of Mr. Justice Harrison a number of times, I think what Lord Nichols says at paragraph 15 is probably inconsistent with that judgment.
Yes. Well, it may... we would say up to a point. Of course, he's considering an entirely different exercise, and of course he's considering it at a later date. So this is the binding authority, and Mr.
Oh, yes, of course.
And Mr. Panic was involved in both cases, and he had considered it to have relevance to the decision. In this case, no doubt it would have been cited.
No, I was regarding this, what I'm looking at now is undermining Mr. Justice Harrison's judgment rather than vice versa.
Yes, exactly. If it was read the way my learned friend read it, rather than the very limited way I suggest it might be read. Yeah. And then set out again the duty. At paragraph 21, we say he says Mr. Martridge's difficulty is this, and he indicates that his difficulty is breach of the section 94 duty. The remedy, he says, in respect of the contravention is under section 18. Though, of course, Mr. Martridge was not bringing a claim for breach of statutory duty. His claim was one in nuisance, albeit in substance, factually, it overlapped. Because factually, he could not get the claim off the ground unless there had been a breach of unless the facts coincided with there having been a breach of section 94. And this, I submit, is an important paragraph. Then,
interpretation under paragraph 21, Mr. Martridge wasn't seeking the enforcement of an adequate system of public sewers. He was just getting compensation for having his house despoiled.
Well, exactly. That's the way he framed his case. But his difficulty was, of course, that as we go on to see, however however one cuts it, it's underpinned. As we'll go on to see in the reasoning, it turns out to be a breach of section 94.
But at this point, Lord Nichols is doing no more than restating the Robinson principle. He's not yet taking it any further.
No, quite so. And we come to where he deals with Robinson in a moment.
Indeed, but that's effectively
Exactly.
the Robinson principle.
Yeah, well, exactly, and that's the way ultimately he puts it. Of course, Robinson.
I know, but what I'm suggesting is don't run ahead of yourself in your reading of the judgment.
I'm so sorry. Yes.
And you see at the end of 22, he construes section 18.8, the last limb of 18.8, in an entirely conventional way.
And that's the way.
And then his reasoning moves on from there. It's when he moves on that you get to the crux of his reasoning.
Quite so. And the way he puts it, he is. We'll come to it in a moment. So 23.
Mind you, even at in paragraph 21, opposite letter C, even before he turns to consider 18.8, he's telling us that in the absence of an enforcement order, the only legal remedy is to pursue JR.
Yes. That's the way the scheme works. The way he interprets it.
Yeah, I suppose one has to regard that as being proleptic and being based on all the analysis that's yet to come.
But then we come to paragraphs 23 to 25. He explains the charging regime and makes the point that new infrastructure must be paid for by customers, and he refers to the charging regime in some detail at paragraph 24. Paragraphs 27 to 28, he explains that the work's been done, so that the remaining claim is only for damages. Then we come 29 following to the meat of the reasoning.
I wonder if, before we come to the meat, might this be an appropriate moment for us to adjourn?
It is indeed an appropriate moment. I think I'm almost on course. I might have to speed up a little.
Thank you. Well, in that case, we'll adjourn this now and resume at 2 o'clock.